Okay, good evening, everyone, and welcome to the Thursday evening online seminar. Tonight we are joined by Mohammed Haque, who is going to be talking to us about the second in his Adjudication Matters series on responding to a claim. As always, you can use the chat and Q&A tools in the bottom toolbar there to ask Mo any questions you like, and he will answer these at the end. Just a point to note, we have had a couple of questions in pre-submitted that were quite detailed. So rather than get into them in the open forum, Mo has details of the people who have asked the question, and he will be responding to you directly rather than trying to address it with everything else this evening. So without any further ado, I will hand over to you, Mr. Haque, and we shall awaiting with bated breath your details on responding to a claim.
Thanks, Julie. Good evening to everybody. And let's jump onto the business end straight away. Those of you are joining today for the first time. I'm Mo Haque, and I'm a barrister and an adjudicator. And by choice, I requalified myself as a quantum expert as well. And for the last 5 years, I've been doing quantum expert report too. Why adjudication matters? If we are in the industry, you know that more than 50% disputes nowadays are resolved through adjudication, despite party costs are not recoverable. And maybe it's because it's very quick. And also it gives us a clear understanding where do we stand. So even if somebody wants to go to the court, it's a good choice to begin with. And finally, the fact that only people who are experts actually sit as adjudicators. So it's much easier to get the point through rather than going to a court and chancing your luck whether the particular judge on the day does understand construction at the right depth you're trying to address him or her. So I have tried to construct a picture for you on the earlier month to go through and take a decision that, okay, I will now do an adjudication as a referring party. Now this time around, we'll try to see how a responding party responds and what do they do and what they should do in order to respond a claim properly. So first of all, the preliminary considerations. You receive a notice of intention to adjudicate first, and within a few days, obviously, if the scheme applies, then within 7 days of that day, you receive the referral. Primarily, the difference between a notice of intention or the notice, although both notice of intention and referral is legally called notice, but we in the industry call it the notice and the referral. The primary difference is that with the referral, you have a detailed account of what the parties or what the referring party is complaining about, what's the basis of his case, as well as the referral adds all the annexures, meaning it tells you what the contract is as alleged by the referring party, what evidence do they have to prove their case, and so on and so forth. So it's not only, I mean, if you are somebody who knows pleading, I would remind you, it's not a pleading, it's not only a statement of fact and particulars of fact, it is the statement of facts, how it happened, your version and the understanding of it, what you want from it, and then why do you think that entitles you to the remedy you're asking for, as well as the evidence you want to rely on. So it's a full package, it's the full story. It's not like a statement of claim or a plaint and a statement of fact alone. Now, what I've been in adjudication for more than 8 years now as a practitioner, as an adjudicator. What I always do is take a stock. What I mean by that is I just create a spreadsheet and do a content list that what it is consist of or made of. There obviously would be a referral, a forwarding letter, maybe the contract will be given, maybe a copy of the notice will be given again, and then a different piece of evidence, including expert evidence and oral witness statements. Now, it is very, very important to take and make a complete list of what has been claimed to have been sent and what has actually been sent, and if it's legible or not, if you can read it or not. All these are very, very vital. And it might sound funny, but as it happened, and there is a case on it where the referring party has sent, accidentally and mistakenly sent a referral which it used under the same contract 2 years ago. And obviously the responding party responded cleverly to that. The adjudicator entered the decision, and then only the referring party realized that, hang on a minute, this was not the referral we wanted to send out. Now, it went to enforcement and the judge enforced the decision. You can understand why it's so important to actually check back. And, you know, two things keep in your mind, that as a responding party in most of the procedures, including, well, of course, the scheme is the most popular one, you do not have an automatic right to respond. So that's your first hurdle. Having said that, as a matter of practice, adjudicators give you an opportunity to respond because he needs to maintain neutrality, and natural justice comes in play, and he must give you a fair chance to respond to the case. So normally they do, but bear in your mind that you do not have a right automatic. And also, adjudication being a 28 or a 42 days proceedings, adjudicators need last 10 to 7 days for writing the decision. So what they tend to do is give you only 7 days to respond. So you've got a very small window to work on. It could be that you know the dispute very well because you have been fighting for ages on a particular issue, and it's been the last resort that they have come to the adjudication. But yet again, you have to, whilst the referring party had months to appoint experts and prepare things, you only have maybe a 7 days window. So what people do, they straightway throw a jurisdictional challenge. So that's one of the other things to consider. I mean, we as an adjudicator see lots of silly jurisdictional challenges, and we're practitioners and still practice as a party rep. So we know that why that's sent, because at least that buys some time. And how do you check the jurisdictional issues? These are normally around conflict and natural justice. These are around threshold jurisdiction and internal jurisdiction, and also how many disputes there, and is the dispute a payment dispute, whereas the dispute should have been valuation dispute. I will explain it a little bit more in the next slides. So the first thing to consider if you're thinking about a jurisdictional challenge is, does the referring party have a right to adjudicate? I mean, it brings in a number of things. First of all, the contract. I mean, the contract in question, was it a construction contract? Or even if it was a construction contract, was it excluded? Or even if it was a hybrid one, for example, in a sewage treatment plant, you have civil works, you have mechanical and electrical works, and obviously the civil package will be available for adjudication, but has the party made the application separately? So that's in a hybrid situation. So if you receive, let's say, from a contractor or an employer or a subcontractor, a notice and a referral which involves a contract which partly civils and partly non-civils, and purely comes under the list, there's a part of it which cannot be adjudicated, then if you see there was a combined application or evaluation certificate, you can simply say that the party doesn't have a right to adjudicate. So there are so many. If the party was not the original contracting party, I've touched on it last occasion as well, that it's not unknown that people start in the construction industry as a partnership or a sole trader, and then all of a sudden the business grows and they become a limited company, and the HMRC give them the same VAT number, but then they have not novated, or they don't novate the contract to the new company. So the money is going to the new company, limited company, and the contract remains with the old parties. And even quite often people even forget to make the original contracting party the party. And the first thing, if you note that, then you can just go back and say that you are nobody to adjudicate. So there are so many different points there where we can simply say that the party doesn't have a right to adjudicate the way it's adjudicating. Now, how many disputes are there in the referral? One or more. Now, unless it's very obvious a difference, like a valuation dispute and a payment dispute, sometimes it's difficult to convince the adjudicator, just because the redress sought have different things or parts in it that they're referring to two or more disputes. Also, if you're a referring party, what you can cleverly do is that even on a dispute under two separate applications, if you say that how much money you are entitled to, so if that's how you set the redress, you can actually save it from being knocked down by the responding party. But obviously this is something to analyze more, how many disputes are there, and that could be another ground for your jurisdictional challenge. Of course, the other threshold points are if the right procedure has been followed. So we know that the vast majority of adjudications are under the Act and the scheme, but obviously if there isn't any adjudication provisions, then the default position is that the Act and the scheme applies. If, for example, like JCT, the parties by agreement incorporate the scheme and the Act and its provisions, it could be that the parties have decided to follow some other procedure. Now, one of the mistakes people sometimes make, that the nominating procedure or the nominating body may be some institution which has a separate procedure, but the parties may in their contract provide that, for example, the CIC is going to be the nominating body, but the scheme will be applicable. It's not uncommon. So you have to find out which procedure it follows, and whether for the nominating and for the rest of the adjudication, and whether the appropriate procedure has been followed or not. If not, then that's a good ground. You know, for example, if it's under the scheme, if the referral hasn't arrived within 7 days, no one can save it. Now, you can straightway go back and tell the adjudicator that the referral has been received on the 8th day from the notice of intention to adjudicate. So you do not have any jurisdiction on this circumstances. I would request you to resign as soon as possible. Now, most often than not, what the adjudicator would tell you is, in this case, the referring party will reapply by issuing the notice, and within another 7 days, I'll be reappointed, because that's how the nominating bodies work. So if you actually are up to some extra time, I can grant you that. And because even the referring party cannot rectify or agree to such a extension of time, but the parties can agree on an ad hoc basis, then the adjudication will proceed under the parties' agreement in that contract, and in that maybe if scheme was applicable, the adjudicator will tell you to agree that let the scheme be applicable in this as well. So it may not be the deal breaker, but it could give you some more time. Now, has a dispute crystallized, as I told last occasion as well? This is a very, very difficult point to raise. Most of the time, you will see that the dispute was actually known to the parties. It could be only that a quantum or a sub-issue of the dispute has been added newly. You may try that, as I say, to gain some more time, and you may get 1 or 2 more days. But it can be sure in most cases you won't succeed with this. But again, it may have a tactical benefit of gaining some time. And finally, obviously, there is this preliminary consideration, very important consideration of receiving the referral. That is adjudication the right choice? Because at one end, we have litigation where we can actually resolve very complex point of facts and law, be it more expensive, but you get the right result. And if you play wrong in the adjudication, you may be not given an opportunity to present a case in detail in front of the court. The judge might say that, why didn't you say this when the adjudication was going on? Similarly, there could be that the matters are very informal. Both the parties didn't have proper records, and the rights that are adjudicated under the contract are on balance, might go either way. So I would suggest in such a situation, it's the best practice for the adjudicating parties are to go to a mediation. Now, if you are only responding, you don't have that choice to make, but you can at least offer that, let's sit down, let's settle. And that's also, I've seen many a times used by the parties to gain some extra time, to have a settlement discussion. And no adjudicator on earth can tell you that if you are making some kind of an offer or a settlement effort, not to halt it for the time being. So again, for one reason or other, it may be that you decide to take the route. If you think that, well, I have no other choice but to respond to it, and either you have and you also believe that you have a case which you can prove on balance to negate the claim, then yes, let's go ahead. And let's go to the second point. The preliminary considerations continue. That's the other finer aspect that gives us a chance to actually go and set another type of defense. That, do you agree that there is a dispute between the parties in the same matter under the same contract? So it could be that your answer, for example, if there is a payment dispute, it's obviously, by now we should all know that the higher courts have made it very clear that it's obviously very different from a valuation dispute. And if it's a valuation dispute, it doesn't even matter if an application was valid or not. So that's been pretty clear now. But for example, right at the moment, I'm deciding one which is a payment dispute, but the referring party is clever enough, is well represented, and they have given you, years ago, I couldn't even understand why that's happening, but now I know, of course, that they've given me various evidences which will cause me to include them into my decision to come to, unless you are an expert and it's difficult to present that way, you might say, okay, what's the relevance of all these? But yeah, they say this is an application and this proves that this is worth. So I have fulfilled the requirement of the act, that's cleared the basis and there's a clean claim. So I'm not doing anything fraud. So, and I will have to include those a little bit, and that will actually force the other side not to contest those points again, into a new adjudication, which is a valuation adjudication, because that will be approbation, reprobation problem for them. Meaning that in the earlier adjudication, you couldn't actually oppose to it. So I will not redo it. So that's the reason why you have to very carefully look at whether you agree that you are answering the same dispute and keeping the implications on other disputes which might come forward in the next period of time, and it's under the same contract. Now, if you think that you have another dispute regarding the same matter, and which is you have a right to adjudicate that because it's not substantially the same, in that case, even you may try to use it as a defense by way of counterclaim or set off. So that actually saves you from going on to another adjudication. So that's something. And once you throw the defense, the adjudicator doesn't have any other choice but to consider it if it's a counterclaim or a set off. And you may gain something from there similarly, because if the adjudicator had to note that the evidence are looking good, then in the next adjudication, even if you need to go to another one, that's what the adjudicator decides, you'll have an upper hand. So, well, I've already discussed the referring party the same as the contract. The contract, yes, if you excluded one, and does the referral follow the correct procedure? Does the scheme apply, and was the right nominating body and the procedure follows? I've more or less covered this slide already in my discussion. And then come this part, as I say, the slides above, these are the title or the preambles, where you get from the referral, mainly the particulars, such as the name of the parties, the address of them, the site address, the contract details, and a brief description of what the dispute is all about. So that's more or less, and how the nomination was made, which procedure was followed, and how the adjudicator has taken office, and all this sort of thing. That comes under first few pages of the referral. Well, if I write it within 2 pages at the most, 1 page title, 1 page particulars. But people I see quite often spends 5-7 pages on that. But that's everyone's personal style. Now, then we come to the meaty part of it, that what he's claimed. Now, sometimes it's my style, let's put it this way, to read the redress sought first, and then to read what's been claimed. Why I do that? I mean, as a practicing counsel for years, and then practicing adjudication, and then working as an adjudicator, I always divide the redress sought wise the issues of disputes under each. For example, if a referral says that for the reasons above, I ask the adjudicator to determine that the application dated such and such, number such and such, was a valid application. Maybe a simple declaration, the first one, okay? And it was to be treated as a default notice under the contract, or under the act, or the scheme, whatever is applicable. And then it says, and also number 2, that the gross value of the application ex VAT was, let's say, £332,000. I was just doing the last week one like that, so I picked up the figure of 332,000. And the net due, that's the third one, is, let's say, 90K. And then the fourth one is the referring party, ABC, is allowed or is entitled to interest at the rate of contract rates of maybe 5.1, adding the Bank of England rate, or the Commercial Debt Act's 8.1, adding the Bank of England base rate. So And then obviously let the responding party pay, knowing fully well that the expenses are not recoverable, the fees, the expenses of the adjudicator and of the referring party at ABC Limited. So that's more or less kind of a standard thing. Now, what I used to do as a practitioner, and I got a lot of success due to that, and I do it as an adjudicator as well. So I break them into these 5 different heads. This is the declaration number 1. This is the declaration. This is the maybe a declaration number 2 that the gross value was 332, and then the third one, the net is this, and the fourth one, the interest calculation, the fifth one, the cost and the expenses. If you do that in, let's say, I mean, if you're a QS, you love spreadsheets such as I do. So if you do 5 tabs like that, and then try to summarize, or even 5 different spreadsheets, that which contractual express term they're referring to base their argument that the application was valid. Because, for example, when you consider the validity of an application, the dates matters. Date matters a lot. Now, it could be, and you know there's a very famous case on that, it could be that there was a schedule added of dates for applications into the contract and interim numbers of, let's say, X numbers of dates, 10, 15, 20 dates, in interim cycle of monthly or 45 days, whatever the case is. And the dates are all given. This is the application date, this is the valuation date, this is the date by which the certificate should be issued, this is the date by which intention to pay less should be issued, and this is the final date of payment. All the dates have been listed in a schedule in your contract. And what actually happens, nowhere it's written that if the contract runs beyond the period of the schedule, then the formula which is adopted into the schedule will also continue. It's not written anywhere. So what happens? The date's gone. The parties are free to agree any dates they want to for the interim payments. So the parties do not have any right to make an interim application anymore. Funny enough, I was giving opinion to that particular contractor that this is going to make a problem for you. And I was working for a subcontractor, and I was laughed at. And the contractor said, see, nobody ever raised that question. I said, look, what if the contract runs for a period for more than the schedule? And they said, well, we never had a problem like this. But I said, I insisted, and they included the major subcontractor I was working for, that particular clause into the subcontract, but they didn't include it into the main contract. And what happened? They made a huge interim application, and it was turned down because the schedules have expired. There was no new date of interim application. So it's vital. It's vital if you separate these things separately and then start checking which particular term they're relying on, and does that term allow them to plead a case, you might get something over there. But if you start reading, I have loads of friends, senior adjudicators, read for nothing the referral 10 times, response 15 times, and do not know how to respond, where to go. But if you just separate the redress sort under the subheads and the tabs and in your spreadsheet, and then try to find out under the redress number 1, what has been claimed, what was the contractual basis of it, what facts they have pleaded that this I'm in breach, and what evidence have they relied on. You end of the day go to a very, very clear, structured situation, if to respond, what to respond, and the rest of the sites is just a detailing of the same thing a little bit more. Like when you are talking about, when you said the things, when you, okay, they're talking about a payment application, so I should go to the payment terms of the contract. And then, for example, for a default notice, the NEC generally do not have a provision. So what we do is we go jump to the scheme. Now, try to understand that and follow through that route and pick that up and go to the scheme and find out whether the scheme requirements have been fulfilled or not. So it's just It's just a simple method that the term and the related terms. Many a times, EOTs are claimed, and it's in every single contract. Let's say in JCT, EOT is the concept of that JCT. Once you click one, and one guy has actually did a PhD and his book was published. Once you touch one clause regarding this, there is a complete flow chart which refers you to this, that, this, that, and unless you have completed all the related terms under that head and check it through if the requirements are fulfilled or not, you won't be able to respond it properly. Same for variations on the JCT. It has to be formally informed, formally done. It has to be a change. It has to be like a variation where money, you are entitled to money. If you're looking for money, then they go to the valuation rules and failure, who has the authority to value. So loads of connected clause comes in. So as soon as you locate that this particular referring party is looking for a variation under this contract and is referring to, let's say, clause 4, then you know that you have to go to the valuation rules, you have to go to the procedure, and you got to go to other various clauses, and deducting it from the main part or adding it to the main part and all of this. And then, obviously, if you have then kind of dissected and segregated the referral under different subheads of the redress sort, and you find out, you take a note that this is the particular clause they're talking about, do immediately go and check if you have case laws there. If you do have case laws, don't get excited. Just go to a textbook and try to find out what's the crux of the matter, what rule was decided, if that's relevant to you. If it is, then you can judge whether you have an actionable claim or not once you've gone through the exercise above. Now, then comes the question of evidence. Even if you, those of you, if there is a single one, are experienced in international arbitration, in construction, there is a thing called liability and then quantum separately. So similarly, I have developed a habit of myself, and I not developed it by getting it from a dream or something, from the senior adjudicators, that they first consider the basis of the liability and what facts have been pleaded, without going into whether those facts have been proved on balance. Now, one of the characteristic failure in the responses that we see one statement against the other statement on the body of the referral and the response, but we don't see the inconsistencies of a particular piece of evidence is addressed by the responding party in their evidence. Just I give you an example. A couple of months ago, I was doing one, and the claim was that the employer terminated the contract wrongfully, repudiated wrongfully, not terminated properly. And the referring party said, look, you sent us an email where you said, I'm withdrawing the items, not more than that, the items. You believe, John, I believe you accept that I have the right, we have the right to do so. Now, Linda, our new QS, will contact you and ask you to submit your final account and close it up. Hope we shall work sometime later. Now, this was in a way favorable for the referring party because they wanted to get out of the contract for some other reasons. So they cleverly went back and said that what we understand is withdrawing works like this under the contract is not permissible. And this is a repudiatory breach. We accept the breach and we think that the contract is now terminated, and we will submit you a final account with all the claims that we have. Now, interestingly, into the response, the responding party tried to say that, I was not withdrawing all the remaining works. I just said the items, which means we were talking about one single disputed item, which was above 7,000 of value. You were not interested to come back to the site, blah, blah. So I was just commenting on that. Okay, there was a statement like this. Now, obviously, it was well represented adjudication. The referring party representative momentarily came back with a witness statement that the reference to the fact of final account shows that you wanted to withdraw everything. That extra oral witness has given me the chance to decide that sub-issue and decide it in favor of the referring party. Quite often, I tell you, these are missed, and you lose vital points within your response. So try finding out what evidence has been relied on each single thing, and then you classify the evidences like, is this an oral evidence or a factual evidence, a real evidence, a documentary evidence, or an opinion or an expert evidence? If there is an opinion or an expert evidence, 9 times out of 10, I would request you not to venture to answer that. It's better to appoint another expert to answer it. When you already take stocks of the matter, please do check for inconsistencies. There is a very easy way of doing it. One is take the chronological list of the evidence and date-wise set it, okay? Set date-wise every single thing, and then do a WH exercise. That's my name. I gave this term. WH means you start asking questions like who did it, when did it, where he did it, how he did it, and all that sort of series of questions about it. You will see from the top to bottom, you'll see lots of inconsistencies. And if you can raise them, there's a chance that you can raise an issue of credibility of the evidence. And that's something you do not have cross-examination here, but you can still show that the evidences are not consistent, so these are not credible. Okay. Now, please keep in your mind, just because you have considered jurisdictional issue right at the beginning, don't think that it's a one-off thing. It's a continuous thing up to the end. So please, at every stage, before, even if the jurisdictional thing is now over, you might come up with a second jurisdictional point or even natural justice point. For example, if a particular defense is not entertained or excluded by the adjudicator, and if during the proceedings he says that this is my preliminary decision, that I will exclude it, this may actually be a violation of the natural justice. And a very senior adjudicator has lost an enforcement. I mean, he didn't lose it. The parties went to the court, and the court agreed that the decision should not be enforced just because he excluded the defense. So don't think that the jurisdictional issue is just a matter of the first few days and then completely forget it. There could be something which has been asked for, which was not asked for within the notice. So you might say, I'm not going to answer this, if that suits your case. So, and the next thing I tell you, in my experience of last 7 years, or 8 years in adjudication, day and night, most of the people do not set in their response what do they agree and what do they not agree to. They love to set a generic paragraph that, unless admitted expressly, everything is not agreed. It doesn't help. It doesn't help the adjudicator at all. Please tell the adjudicator that I accept the first sentence of paragraph number such and such, and I do not accept the rest of it. Please set it at the beginning of your response. My humble request, you will give everybody, including yourself, to assess the position, that it's not a quarrel. It's not a quarrel. You are addressing a tribunal. And please keep that in your mind, that when you're addressing a tribunal, the tribunal is very experienced, and they're mostly dual qualified, have got hundreds of adjudication experience in their life. So you just cannot keep thing which is not tight and not responding to the point and crisp. If you tell your adjudicator that these are my agreements and disagreements in a simple table of the referral, and the reasons are gonna be this, you stand a better chance. And as I feel, when I assess the merit of the case as a responding party, I always feel better, and I can see myself whether I do have a case or not if I do this. So do not just think it's oh, they can't say this. Oh, why are they saying that? Oh, it's horrendous. I know this QS, I know this product manager, he's always unreasonable. Forget about all these things. Read the referral, and sentence by sentence, again, if needed, I do it in a spreadsheet. Every sentence I put on a particular cell, extended cell, and I try to say, do I agree or do I not? Only if there is a disagreement, there is an issue for the adjudicator, and then please try to say, are you disagreeing because it is not legally correct, meaning it's not supported by an express or implied term of the contract, or are you disagreeing because it was not evidentially correct or factually correct? Please say this. It will make you feel better and know better your own case. So come the final day, you'll not be frustrated. Now, I've already said that. Do you disagree with the legal basis, for example, the terms of the contract, which they're referring to? I just did an adjudication, just give an example, that was 5% was, it was a JCT contract, 5 plus Bank of England rate was the interest rate. But there was a long amendment list, which was not consulted by the referring party, where it was brought down to 2%. And that was pointed out by the responding party that the legal basis is wrong because that clause has been amended through the process. So, and if you agree, the legal liability still is not the end of the case. The quantum is a very, very important thing, and you may not agree the quantum of it. And if you have valid defense on quantum, you may, for example, the worst scenario, I just give you an example. I think 5 years ago, it happened to me. It was an international arbitration. The claim was 42 million, and we literally lost every point on liability, including, the team was led by a senior QC and the 2 other barristers, and me and another, I'm a dual qualified, and another person was a purely quantum expert. It's about a six professionals team. And we lost literally every issue into the liability phase. But the quantum was so good from our end that the 42 million claim was brought down to 3.8 million. So do not just think or be scared that, it seems they got it because the contract says they got it. There could be a very vital quantum issue there. And if you can raise the quantum issue right, it could be that the adjudicator say, yeah, I agree, that's he's entitled, but he's entitled to 1/10 of what it's called asking for. Adjudicator is not going to do that for you if you don't divide it like that. So, yeah, and then finally, do you have a counterclaim or a set-off? It's very important, because even if you do not have any answer to the claim itself, you may have a counterclaim or a set-off which you want to set it up. So, and I think I'm done.
Okay, thank you, Mo. And someone's actually asking here if you could provide an example to one of your spreadsheets that you use for an adjudication, or a template, if possible. I don't know if that's possible, but if that is, we can certainly sort that out. Well, I will not publish it,
but if the person contacts me, I'll be happy to share it with them.
No problem. Okay, understood.
As many people want to share, want it, I'm happy to share with them separately, but I don't want to make it too public.
Understood completely. Okay. Some interesting questions here. Someone's asking, how many years of experience is essential to become an adjudicator?
Well, let me give you an example then. I mean, you are in England, so you know something about cricket. Shane Warne, the world's #1 leg spinner, only has 6 months experience before playing in the test team. And I know many who's around 50, still trying to get in, but couldn't cross the first class hurdle. So it depends really. I mean, I'm not trying to be harsh. It depends. Now, the point is actually to, again, to which level, because, for example, you need to to have a recognized diploma, first of all, either CIR level 4 or the RICS level 4 or something equivalent to it. I don't know if anything else exists. So you have to have that on your side. And then you have to have some practice experience. Now, I have seen in reality, another important thing is getting mentored, because there are two aspects in it. One is, first of all, you got to, I mean, before even thinking to become an adjudicator, I had almost 150 adjudications completed, and as a party representative. And time and again, the adjudicators who I was presenting cases to, or even presenting in the meetings, they say, Mo, where are you? Why are not you applying? You know, you should come on board. So these are the same group of people who will be actually on the recruitment panel. So what actually happened when I applied for the RICS President's Panel, I had never been in a LVD or anything like smaller panels. So when I applied to the RICS President's Panel, I knew the president, I knew the recruitment. So much so on the familiarization day, both the seniors who were presenting the familiarization day, they had to make it clear that we are very closely connected to Mo, because he did hundreds of cases with us. And as such, I have to tell that we know. And one of them actually was my referee. So it all depends, but it took 3 years only for me to reach up to that point. And I saw other people in my same firm where I was working, they're maybe doing 15 years and couldn't even apply because they're not a fellow of the Chartered Institute of Arbitrators, RICS. If
Right.
that helps.
Okay, thank you for that. Okay, that seems to be covering the questions that we had. So it only remains for me to thank you very much for sharing your time and expertise with us again. I believe the next edition for this series, the Adjudication Matters series, is on the 11th of March, when you'll be talking about defending a claim. So we very much look forward to your hints and tips from that. Thank you. Thank you everyone for attending tonight. The certificates will be out. We do have 2 seminars next Wednesday, morning and evening. John Sharp is presenting the Brexit effect at 8 a.m, which is a wonderful way to start the day, both with John Sharp and with Brexit. And then 6 o'clock, we have Richard with his latest in his construction essentials, which is contract interpretation and damages at large. So if anyone would like to book onto any of those, please let me know, and we will book you in. Otherwise, everyone have a good evening, and thank you very much again, Mo. It's very much appreciated.
You're welcome. And I thank everyone for attending. Thank you.